Okay, now over to you, Rajesh. Advocate Rajesh, over to you. Rajesh sir, please start. Rajesh sir, can you hear me? Advocate Rajesh. Rajesh sir, please start.
Hello, Mr. Rajesh. Uh, Raksha madam. Hello.
Yes, sir. Just give me a 2 minutes. I'll talk to
No.
him and we'll get
Yeah.
back to you, sir. Just a sec.
Okay.
Um, Friends, there is a technical issue with Advocate Rajesh. Just we will wait for 30 seconds. He will join again.
Hello, hello.
Yes, sir. We can hear you.
Yes,
Yeah, Rajesh ji, you are audible.
Please start. Please
yeah,
start.
thank you. Uh, Good afternoon, all. This is Advocate Rajesh Menezes, practicing labor law and HR consultant. This webinar is organized by Legal Cell, Law and Alliance, and powered by media partner LawScom. We have among us the elite personality, NC Bipindra, Advocate Supreme Court. He is a founder of Legal Cell, chairman of Law and Society Alliance, and editor of Defense Capital magazine. Advocate Kumar Vaidyanathan, Advocate High Court. He is the secretary of Law and Society Alliance and co-founder of Legal Cell. I would now like to introduce our today's speaker, Advocate Mahesh Shukla, who is going to conduct this session on MRTU and PULP Act and latest Supreme Court order on wage and its implications. He is practicing since last about 17 years in matters related to labor law with particular focus on human resources. He is having a huge clientele like Hajj Committee of India, Ministry of Minority Affairs, Government of India, Agro Industries Corporation, Special Council for Rural Development, State of Maharashtra. He is also advocate on record for Bharat Heavy Electric Limited. He is also advocate for Sahara advises for Sahara India, Adlab Private Limited, Trick Securities Private Limited, and go on. I'm sure we all are going to witness an interesting and knowledge enriching experience. I request all participants that during the session, if you have any query, please drop the same on chat box of Advocate Mahesh Shukla. He will definitely try to answer your queries. Please mute your speaker so that we'll able to listen our speaker well. Now we'll give over to Advocate Mahesh Shukla for an interesting session. Mic is yours, sir. Thank you.
Thank you very much, Rajesh. It is really pleasure on this platform of legal, cell, and law and society alliance present. I'm really grateful to all of you who firstly invite me for such on a platform of such a forum, which is working, I believe, rigorously every day to have sessions on various subjects. Your efforts are remarkable, wherein you're trying all your audience to understand the various uh, law and its implications. I'm I'm specially my special thanks to Mr. Kumar Vaidyanathan and also my deep condolence for the unfortunate incident. And still his spirit let me record that he called me half an hour before and he said that this you even on this sad occasion when he's going to attend the funeral, he had boosted and he was so humble to inform me about it. Anyways, grateful to you all not taking much time and coming to the subject. Now, MRTU and PULP Act, my friends, let me inform you. It is the Maharashtra Recognition of Trade Union and Prevention of Unfair Labor Practice Act 1971. All my friends who are practicing in labor law, this is a subject like a Bible to them. Now, 1971, this act has been enacted for the first time in the state of Maharashtra. Let me inform you, this is a very vital information for all my audience, that MRTU and PLP Act is such an act which is an act which prevails only until the boundaries of the state of Maharashtra. No other state in India has such an enactment which prevents the unfair labor practices causing against both an employer and the employer both. Now, though this is very exhaustive and the time duration which we have is very less, so I've tried to brief the entire subject in nutshell. And according to me, I have divided MRTU and PULP Act into basic two parts. Let me take you all to the first part of it, that is part one. As you see with the caption of this act, it says Maharashtra Recognition of Trade Union. So this I would define as part one of this act. Now, part one of this act, that is recognition of the union, you will find it in section 11. Now, section 11 enables the recognition of an union in any undertaking. Now, recognition is an exclusive right which is conferred upon union, which is much illustrated in section 21, 22, 23, and 24 of the Act, wherein the rights of recognition of the union is well illustrated. It also illustrates the rights of unrecognized union. Now, coming further to this part 1, section 13 of the same Act has also provided for cancellation of the recognition of the union. For an example, let me take you for fractions of seconds. If there is an union which is recognized since long into an establishment. But subsequently, the members of it switch over their vote of trust to some other union, and they intend that the another union where now they have switched up their membership is should be made recognized. In such situation, the union which has recently got majority and having 30% and more members of the undertaking can apply under section 13 for cancellation of the original recognition of the union which is existing. By this, you will understand why I have pointed out. You will understand that this act has not only taken care of the protection of the employees, but also the subsequent development. It is not so that once if an union is recognized, it is recognized forever. So there is no monopoly of an union. Basically, this intent of the legislature in this part is to evade the monopoly. So this I wanted to point out to you in a very categorical manner. Now switching over you all to the part 2 of this act, that itself can be seen as prevention of unfair labor practice. Now prevention word itself says that kavach, let me tell you that it's an so friends, I want to divide in two parts. The unfair labor practice can be meted out against the employees, majorly as we see. It can also be against the employer. Now, this act has protected the rights of both parties, as we see. Now, if you all turn to Schedule 4 of this act, as if you see there, now here there are several items illustrated in the Schedule 4 of wherein dismissal, termination, and such types of events which is apprehended to happen or has happened is provided for in such schedule. Now, Schedule 4, Item 1A is a provision which has jurisdiction before the labor code, that is dismissal, termination, and such type of colorful exercise of the employer. I'm not going in detail because this can be read for and I have to switch over to the other subject also. Now, coming to the next schedule, that is Schedule 3. Schedule 3 is an provision which protects the interest of the employer. We have seen that it is not only that the unfair labor practice is caused upon the employees, but it is also caused upon the employers. So here, like blackmailing tactics of the union, of Gherav, Dharna, Morcha, or endangering the life, property, and security of the premises of the employer is taken care of. So this very item here provides for such. There are other aspects also, like Section 48 provides for the contempt. Section 50 provides for recovery of the dues. Now, Section 44 here has the jurisprudence, the industrial court has the jurisprudence upon the labor court. Like any labor court ULP matter can be challenged before the industrial court in form of section 44. Now, friends, in short, this is what the MRTU and PULP Act. It is very illustrative and it is in such less time, it is very difficult to explain the minute part of it. However, I have tried to take you to the glimpses of this. Now I switch over to the next subject of today, that is the implementation of the Supreme Court order. Now, friends, Supreme Court order, which was passed on 12th June 2020. Now, this order was in writ petition number 10983 of 2020, wherein several parties, employers, have approached the Honorable Supreme Court being aggrieved of the advisory which was passed on 29th March 2020. Now, what was this advisory? This advisory was which directed the private employers to make full payment of wages during the period of lockdown. Now, this advisory, which has been issued in accordance to Section 10(2) and 1 of the Disaster Management Act. Now, this very section has been invoked while circulating this advisory. Now, these employers who are being aggrieved of this very advisory have argued before the Honorable Supreme Court, which is also well recorded, that this advisory is in contravention to the provisions of the Article 14 and Article 19(1)(g). Now, friends, Article 14 is right to equality. The state shall not deny to any person equality before law. Now, illustrating and elaborating it further, the Industrial Dispute Act, the Payment of Wages Act, the Minimum Wages Act, this all act provides for the right of the employer wherein the wages can be deducted. Now, in circumstances where the employer, with no fault of employer, he is unable to conduct his regular business, and hence, in such circumstances, he is unable to pay the wages to his employees, which is out of his control, and hence the invocation of the provision of 10(1)(2) of the disaster management, according to the petitioners, are in contravention to the other statutes. It now they have also invited the aspect of violation under 19(1)(g), which provides for the right of practice of any profession by any person or any occupation or trade therein. Now, here as we see that our constitution is very illustrative and is very vast, and it has broadly taken care of almost every segment. Now, the right provided under 19(1)(g) is of its independence of conducting profession, occupation and trade of his choice. Now, conducting an business is also very much protected under the is very much conducted. Am I audible?
Yes, sir. Yes, sir.
Hello. Is very much
Yes.
falls under the purview of very much falls under the purview of 19(1)(g). The employers have also drawn the attention in the aspect of the Industrial Dispute Act, Section 25(c), which provides for layoff in such circumstances because they are unable to conduct their business, so they have a right to lay off. Further, the aspect of 25(f), which is provided under the Industrial Dispute Act, which illustrates on the fact of retrenchment. Now, all these points have been taken into consideration by the petitioners and has been vehemently argued before the Honorable Court. Now, Honorable Court has gone in depth of the entire issue, and 28 pages order has been passed, which has covered almost all the aspects, and the court, Honorable Supreme Court, is of the view that at this scenario presently, when these all disputable and arguable aspects are for consideration before the Honorable Court, the only best option to resolve this issue is by an amicable means. It has been very categorically and emphatically expressed in my words, let me say, that the worker and the employer are wheel of the industry. They both are two wheels, and hence the industry cannot survive with either of them. So in that situation, an harmonious relation has to be maintained, and both segments have to understand difficulty of each other. In this backdrop, the Supreme Court has advised that both the parties should sit together and amicably resolve the issues. Further, if there is still any dispute pending, the conciliation as provided under the Industrial Dispute Act can be invoked, and the dispute can be referred for the conciliation. In short, the aspect of mediation has been emphasized more. I will take you all to the operative part of the order, which says that the private establishment industry employer who are willing to enter into negotiation and settlement with the workers employees regarding the payment of wages for 50 days or for other period or applicable in the particular state during their industrial establishment was closed down due to the lockdown may initiate a process of negotiation with their employee organization and enter into a settlement with them. If they are unable to settle by themselves, submit a request to the concerned labor authority, who are entrusted with the obligation under the different statutes to conciliate the dispute between the parties who are receiving such requests, may call the concerned employees, trade union, workers association to appear on the date of the negotiation. In event a settlement is arrived, that must be acted upon by the employer and workers irrespective of the order dated 29th March 2020. Those employer establishment industries factories which are working during the lockdown period, although not to their capacity, can also take steps as indicated. The private establishment industries factories shall permit the workers employees to work in their establishment who are willing to work, which may be without prejudice to the right of the worker employees regarding the unpaid wages of 50 days. The private establishment factory who proceed to take steps as per the direction 1, 2, and 2 shall publish and communicate about their such steps to the workers and the employees of their response. The settlement, if any, as indicated above, shall be without prejudice to the rights and of the employer and employee which is pending adjudication in this writ. Central governments and all state UT uh, may circulate and publish this order for benefit of all. Now, very essential aspect in this matter is that the emphasis has been made for negotiation, and 2P settlement can be drawn, according to me, under 18(1) of the Industrial Dispute Act. Now, let me be honest on the aspect that the circular of 29th March 2020 was withdrawn on 17th May 2020. So technically, as you also see, the court has observed and has expressed its concern for those 50 days wherein it was mandated by the advisory to pay wages, and in circumstances where the employer is not in a position to pay their wages. Now, there are several options which can be invoked. In my opinion, the employer and the representative of the workers, either union or otherwise, can draw up a settlement which can be registered under section 18(1) of the Industrial Dispute Act. This can be either in form of the waiver of the wages for the stipulated fever in totality, either reduction of wages for the relevant period in totality, or also, as we have seen the practice and the scenario at that moment, that many of the employers had requested their workers to go on leave. Now, even this leave aspect can be recorded into the 2P settlement by consent, that they forego their this number of days amongst so many days as leave, and they are not entitled for the wages for this period. This is an attempt to prevent the fall of the industry, and hence such attempts can be made, and this would be a successful effort Now, this is worth mentioning here that even union representatives have also intervened into the said application, that is the petition which I've already stated, and have supported the advisory. Now, the purpose is not about who supports and who disputes the advisory. The observation of the Supreme Court is clear that we have to set up an example amongst ourselves and let us be very clear that the resolution can be done by amicable means only. And hence, friends, concluding on this line of the Supreme Court judgment, let me tell you essentially what is very important by this judgment, that for those number of days where it has been burdened upon the employer to pay the wages, especially for the 50 days as the court has recorded, they can come up with a solution and resolve it amicably. Friends, this according to me is one of the best way out to run our business and advise your clients, as well as if I have audience as employer, if I have audience as union, if I have audience as worker, to sail the industry. The intent has to be to sail the industry. By this, I conclude my representation on both the subjects and open up for Rajesh to look into the chat box, and if there are any queries that can be addressed for another 5 to 6 minutes, because our time limit is up till 3:05. So there are another 8 minutes in which I would like to cover up the queries of my audience. I'm really grateful once again to all my audience who and the organizers who have invited me today on this platform. Thank you.
Thank you very much, sir, for your
Over to
wonderful.
you, Rajesh.
Yeah, yeah. Sir, there are a few questions. One question is from Advocate Purnata. She wants to know whether this Supreme Court order says only about wages or termination also. Hello? Hello?
Yeah. Can I?
Yeah. Yeah, yeah, sure.
As you see, the general ambit of the petition is in regards to the implication of the wages only. Now, there cannot be any settlement to the effect of termination. Please understand. So, the dispute is, as of now, for the unpaid wages during the lockdown period of 50 days when the when the advisory was operative. So, this sticks to that. There cannot be a settlement, because when I have tried to illustrate on this point, there can be no settlement on termination. Hence, this order is centric of wages.
There is one more question from the participants, Mr. Neeraj Pandey, that if suppose an employer asks for a resignation or a termination with 1 month notice pay, salary also they are paying. In that case, that employee have right to file a complaint or not.
Forcing of resignation and force and termination both would come under the our first issue of discussion today, that is MRTU and PULP Act of Unfair Labor Practice, where I have pointed out item 1. So in all scenario, in situation of dispute, every worker will have a right to raise his voice legally, I mean to say, in form of such complaints of unfair labor practice before the appropriate court.
That's it, sir. Thank you very much for your session.
Thank
And
you,
I
sir.
must mention and give special thanks to Advocate Mahesh Shuklaji for he being here in spite of having fever, and for an interesting session and valuable time he has spent with us. Thank you very much, sir. Our next webinar will
Thank
be held on 27 July at 2:30 p.m. on introduction of HRM. You all are requested to kindly join the same. And before we conclude, I would like to thank all participants, the organizer, the media partner, and our technical team. We'll now conclude the session. Thank you very much.
Thank you, sir. Thank you very much.
Thank you, everyone.
Thank you.